Good afternoon, everybody. Welcome to another question and answer session live. My name is Samara Belitzky, and I'm an employment lawyer at Samfiru, Tumarkin. I'm in Ottawa, but I do practice in Ontario and BC. So I'm here to answer all of your questions that you may have today regarding employment law, whether it be severance, issues with terminations, issues in the workplace. Maybe you're having changes that are being implemented to your terms and conditions of employment. Whatever the question is that you might have, I'm here to answer it. I'm also here to answer any questions you might have regarding disability law, disability benefits. Maybe you've had to take a medical leave of absence from work. Perhaps you're in the middle of applying for disability benefits or you've had a claim denied. Any of these questions, I'm happy to answer them. Any issues you're having, whether it relates to these issues, please send in your questions. Maybe it's something you've been dealing with yourself. Maybe it's something that a friend or a family member has been dealing with. But any inquiries that you have, now is the time. I'll be here for the next half an hour or so to answer any questions that you might have. I will start off, as I normally do, with a few topics that I have prepared that I've had a lot of questions about over the last week or two. As always, I'd much rather answer your questions. So if you have your questions, please send them in. I'll get to as many as I possibly can. For the time being, the first thing that I wanted to start off discussing, and I'll probably sound a little bit like a broken record if you're watching these sessions regularly, is mass layoffs, mass terminations. And the reason for that is we've seen so many of them in the last little while. It's become such a prominent issue. You've likely seen it in the news every week. There's a new company that's engaging in a mass termination or a mass layoff. And so because of that, we keep getting questions about it. We keep being in a position to assist people who have ended up being part of a mass termination or a mass layoff. And so because of that, I wanted to touch on it briefly because I have touched on it a lot in the last few sessions that I've done. But again, we keep getting questions about it, so I want to make sure that I touch on it. So what's really important to understand when you're dealing with a mass termination or a mass layoff, those terms are interchangeable, is it's a situation where a company is permanently terminating the employment of more than just a few people. So for example, in Ontario, it's 50 or more people at one given time. So if you're dealing with a termination and you're part of that, whether it's a big restructuring, in any case, it can be 100 people, 200 people, 51 people. But if it's a mass termination, there are special rules that apply under the Employment Standards Act. So whether you're in Ontario or even if you're in another province, there are special rules that apply. And those rules are found in the province's Employment Standards Act, which is the law that contains the bare minimum rights and obligations of an employee and an employer in the employment relationship. And so when we're dealing with a mass layoff or a mass termination, the Employment Standards Act is going to provide bare minimum obligations that an employer has to comply with, which on the flip side will provide you with the employee's bare minimum rights in the event of a mass termination. Now, keep in mind, I'm using the words bare minimum because that is exactly what's outlined in a province's Employment Standards Act. It's just the bare minimum. It's just the starting off point. So when we're talking about mass layoffs or mass terminations, the starting off point for somebody's severance or termination entitlements will likely be more when it's part of a mass termination. So for example, in Ontario, if you're part of a mass termination, you will be owed more than your bare minimum. So if, let's say, you might be owed normally 4 weeks as your bare minimum, you might actually be owed 8 weeks instead. Again, just as a starting off point. That's where the real difference lies when we're dealing with mass terminations versus a regular termination where an employer is not letting go of many, many people at once. And so what's really important to know is that when we're dealing with mass terminations, somebody's full severance, your full severance entitlements, your full termination entitlements will still be the same. So in other words, it's not because you're part of a mass termination or a mass layoff that you're going to be owed less severance. In fact, as I mentioned before, as a bare minimum, you'll be owed more. Just your bare minimum, just your starting off point will be increased. But when we're talking about your full severance, which is what most people are entitled to receive, that will not be reduced. That will not be negatively impacted by any factor related to a mass termination or a mass layoff. The analysis will remain the same for your full severance, meaning it would be based on things like your age and your length of service, among other factors. So keep that in mind. If you are someone you know is impacted by a mass termination or by a mass layoff, usually it's just going to mean that your bare minimum entitlements will be increased, but you would still be owed, in the vast majority of cases, your full severance. So I have a few questions coming in. I'll get to these questions and then I'll go back to my list that I had prepared for topics. So I have a question from Renee on Facebook, who asks, I was told that I am not entitled to OT pay, overtime pay, if I work on the weekends. Is this true? So Renee, generally speaking, when we're dealing with overtime, there isn't a distinction between weekend or weekday. The way that overtime pay works, and I'll give you an example, is if you were to be working in Ontario, if you're working for more than 44 hours per week, there's no distinction on whether that's a weekday or a weekend. Any day in 1 week of 7 days, if you work more than 44 hours, you are entitled to overtime pay for all hours worked beyond 44. And it would be equal to time and a half. So if you worked an extra 5 hours, you would get an extra 5 hours paid to a time and a half. There are other agreements that employees and employers can enter into when they're dealing with these issues. So for example, if an employer wants to, instead of paying you time and a half, have you bank those overtime hours, and you have an overtime pay bank where instead of getting paid, you can take that as time off, that can be arranged, but there has to be an agreement between the employee and an employer to do that. And so a lot of employers might implement that policy where they say anything over 44 hours, you're going to get your time and a half, but it's going to be banked. And then you can take it as time off. Again, there has to be an agreement for that. And it still has to be calculated at a rate of a time and a half. So in other words, if you work an extra 5 hours in a week, it's not that you bank 5 hours, it's that you bank time and a half for those 5 hours, so that you're still getting the same value for the overtime, whether you're banking it or whether you're getting it as pay. The other thing that an employer can do is an overtime averaging agreement. So generally speaking, the default is that if you work more than 44 hours in 1 week, you get paid time and a half, or you bank it at time and a half for anything over 44 hours in 1 week. There are situations in which an employer can put in place a written agreement, an overtime averaging agreement, where you can, for example, average over a 2-week period. So instead of it being anything over 44 hours in 1 week, you would carry that to 2 weeks, so that it would be anything over 88 hours in the 2-week period. And some employers might do that because in 1 week you may work over 44 hours, but in another week you may work 20 hours. So when you put the 2 weeks together, you would not be over the 88 hours in the 2-week period, and then there wouldn't be the overtime pay that would need to be provided. So a lot of employers will implement that when they're in a situation where you may work a lot in 1 week, but not as much in the week previous or afterwards. And so it's a way of managing overtime pay. Again, if an employer wants to implement that, there has to be a written policy in place. There has to be the agreement of the employee, and there are very specific steps that need to be followed by the employer to have a valid overtime averaging agreement in place. So all of that to say, Renee, the fact that you work on the weekend or not has nothing to do with whether you're owed overtime pay. It really has to do with how many hours per week you're working. And if you are working more than 44 hours a week, or if you're governed by an overtime averaging agreement, whatever the number is, if you're working more than that, you're owed overtime pay. Simple as that. It does not have to do with whether you're working on the weekend or during the week. If you're not getting the pay that you're owed, Renee, we can assist you with that. You can get in touch with us. We're more than happy to assist you with this. The other option you would have, if it's just a question of overtime pay, would be to go to the Ministry of Labor. And you could file a complaint for overtime pay that's owed, and the Ministry of Labor would investigate it And then if you are owed overtime pay, they will order your employer to pay it. So that's another option for you. I have a question from Michael on YouTube who says, my boss has told me verbally that they're going through financial difficulties and alluded to a pay decrease. Is this allowed? He's made sure not to confirm any of this in writing, just in conversation. So in terms of a pay decrease, what you have to look at, and you won't know this until it actually is proposed to you or forced on you, we're looking at what the reduction actually would be. Generally speaking, an employer is not allowed to reduce your pay without your consent. However, in terms of having legal recourse to push back, the reduction has to be significant. And so when we're looking at what's significant, it would have to be a reduction of around 10% or more in order for it to hit that threshold of whether it's a significant change. So if they're going to reduce your pay by 10% or more, that is something that you could have legal recourse for and push back on. You don't have to accept that. If it's less than that, you may have difficulty with pushing back and with having legal recourse. So again, it does depend on the significance of the change, how big of a reduction it will be. It will also depend on whether that reduction is temporary or permanent. If it's temporary in nature, then you may not have that legal recourse available to you. If it's a permanent reduction, then absolutely you would have that legal recourse available to you to push back. So it's very important to make sure that when you are made aware of these changes, you do get in touch with us. It's very important to speak with an employment lawyer right away when you're dealing with these issues, because it is quite a delicate situation. And you want to make sure that you don't do or say anything that would possibly hurt your legal position moving forward. You want to be in the strongest legal position possible. And oftentimes when we're dealing with issues like this, reduced compensation, changes to the terms and conditions of your employment, the legal recourse that could be available to you would be a claim for constructive dismissal. And when we're dealing with a constructive dismissal claim, meaning your employer has made a significant change to the fundamental terms of your employment and they're forcing it on you without your consent, you do have the ability to assert a constructive dismissal claim and push back, but it has to be done in a very specific way. And you cannot keep working under the changed conditions. So it's very important that you do get advice from an employment lawyer, that you express your refusal to these changes in writing and right away, so that there's no question that you are not accepting these changes. If you continue to work under changed terms of employment, it will become a deemed acceptance. You will be assumed to have accepted the changes, even if you haven't said, yes, I accept. Just working under those terms and conditions will be a deemed acceptance, and then you're stuck and you won't be able to do anything about it. And not only that, your employer will then be able to make further changes later on because you've accepted these changes. So you have to be very careful as an employee that when these types of things are happening, when changes are being proposed, that you get advice on whether they're significant enough to have legal recourse and have an ability to claim constructive dismissal, and how to go about doing that if you have that legal recourse available to you. And as I mentioned before, it is a very delicate process and you have to proceed very carefully. So if you're in that situation, as soon as you find out what the changes are, get in touch with us. We're more than happy to assist you, review the situation, and figure out what the law says about it and what your options are. So I have a question from YouTube, from Baba on YouTube, who says, where I work, they don't have funding anymore. They applied for funding, but won't hear until May. If we get it, we won't start until August. If I look for another job, will I get severance pay? I'm a seasonal worker. So what's not clear is whether you're currently working or if you've been put on a layoff. If you have been put on a layoff and you're a seasonal worker, and this is the same time of year every year in which you're put on a temporary layoff and it's become a condition of your employment, If you do find other work during that period during which you're normally on a layoff, that would be fine. You can look for another job. You can work another job. In terms of whether you'll get severance, that's a completely separate issue. So if, let's say, they don't get funding and they don't call you back within the time frame that they usually do each year, and you know it's a specific month or a specific time frame every year where they call you back. If they don't call you back at that point, then it could be a termination and you could pursue your severance. So I'm missing information here in order to really advise you, comprehensively. But if you'd like to speak to me directly, you can always contact me directly. My contact information is on our website at employmentlawyer.ca. You can also contact us at help@employmentlawyer.ca to speak to any of our lawyers to go over the situation with you in more detail, because depending on the facts of this and the context, my advice could be different. So based on the information you've provided, that's all I can kind of tell you for now. So if it is a situation where you're being laid off each year, it's the same time of year every year, and you're not called back by a specific time when in the past you have been called back at that time every single year, that could amount to a termination and you could be owed your severance. But simply going to find other employment during that layoff period, that in and of itself would not entitle you to severance. And in fact, that in and of itself, it's not a termination, it's also not a resignation. So you would be doing temporary work in theory until they call you back to work. If, let's say, they call you back to work and you refuse because you like your new job better, then that would be a resignation and you wouldn't be owed anything. So keep that in mind moving forward. It sounds like an interesting and complex situation. So again, I do encourage you to get in touch with us so we can review your situation in detail and give you more comprehensive advice. On that note, I'll also mention that with respect to temporary layoffs specifically, since we are on the topic, it's very important to know that when you're put on a temporary layoff by your employer, most of the time they don't have the right to do that. So the only way that an employer has a right to lawfully place somebody on a temporary layoff is if you've had a previous layoff where you've gone on a layoff, you've come back to work, business as usual, and you've continued working. That means that temporary layoff then becomes part of the conditions of employment and the employer can lay off again in the future. The other way that a temporary layoff would be lawful and that an employer could implement a temporary layoff would be if the employee signs something that would agree to it. So for example, an employment agreement. So if an employer puts a temporary layoff clause in an employment agreement, and as an employee, you sign it and you agree that they're allowed to temporarily lay you off, then again, the employer can do it. Absent those two situations, the employer is not allowed to put an employee on a temporary layoff without their consent. So if you're in a situation where you're being put on a temporary layoff for the first time, it's really important to get legal advice on your situation right away, because you may be in a situation where you've never been laid off before, you've never signed anything that gives the employer the right to lay you off, and so the employer doesn't have the right to do it, and you can actually refuse the layoff. You can treat it like a termination of your employment, and you can pursue your severance pay and your termination entitlements. So it's really important to move on that quickly when that does occur, so that you make sure you're pursuing what's owed to you right away. Keep in mind that doesn't mean you have to go after your severance. It's a possibility, but sometimes we do assist people where they just want to get back to work. They don't want to be on a layoff, and we help them just get back to work. So there are different resolutions available depending on what the goals are and what the employer and the employee are trying to accomplish. But from a purely legal perspective, an employer is not allowed to do that. They're not allowed to implement a temporary layoff unless an employee has agreed to it in writing or there's a previous layoff. And what's important about that as well is if you are put on a temporary layoff for the first time, if you do nothing about it and you wait and then you get called back to work and you go back to work, it then becomes part of the conditions of your employment. And you're now in a situation where the employer can lay you off over and over and over again in the future, and there wouldn't be anything that you can do about it. So it's really important when you're in that situation that you act on it, that you get advice, and that if you do want to refuse it, that you do so as quickly as possible. So I have a question from Carlotta on Facebook, who says, what can you do if you're fired due to false accusations? I was not offered any severance either. Okay, so it sounds like you were likely terminated for cause, or I should say allegedly for cause. So if, let's say, you are in a situation where you've been terminated for cause, meaning the employer is alleging serious misconduct against you, and taking the position that because of this misconduct, you're not entitled to receive your termination entitlements, they would have to provide the reason for it. That's number one. And then they would have to provide you with the details. Now, usually when we're dealing with misconduct, there would have to also be what we call progressive discipline implemented. So if, let's say, it's a situation where there's extreme misconduct one time, for example, an employee assaults another employee, an employee commits time theft or fraud, there are very serious instances of misconduct where, as an employee, if you engage in that kind of misconduct, it's you're going to be terminated immediately for cause, because there's no gray area. There's no way around that. It's a very extreme instance of misconduct. If, however, there is possible misconduct, or there is misconduct that's less severe, such as being late for work, missing work, performance issues, these are the kinds of misconduct that we see most often. And in those cases, the employer has an obligation to apply progressive discipline. What that means is the employer has to warn an employee that they're not performing to their satisfaction, that they're having certain issues. The issues have to be brought to the employee's attention. They have to be warned about it, has to be done in writing. And there's a very specific process that needs to be followed. And specifically, the employee has to be warned that if this issue doesn't get improved upon, it may lead to a termination for cause. Now, if an employer doesn't follow that process and then terminates for cause, it's very unlikely that an employer will be able to justify a cause termination, meaning a termination where the employee doesn't get any notice or any severance. And that's because, as an employer, justifying a termination for cause is very difficult unless there is extreme misconduct, like some of the examples I just mentioned. And more specifically, when we're dealing with performance issues, this is actually something that's come up a lot in the last couple of weeks, where I've been getting questions from employees and employers about performance issues. There are oftentimes employers who will terminate for cause for performance issues, but that doesn't mean that the employer actually had cause. And oftentimes when the reason for termination is performance, it will not amount to cause at law. So even if an employer tries to terminate for cause and tries not to give any severance, that doesn't mean that that's correct at law, which is why it's always very important to get the situation reviewed by an employment lawyer, because more often than not, a termination for cause or an alleged termination for cause by an employer is not actually a termination for cause. It really does depend on the circumstances. And when we're dealing with performance issues especially, it's very, very difficult to justify a cause termination, especially if an employer hasn't taken steps to implement, for example, a performance improvement plan and try and help the employee to improve on the things that they are struggling with so that they succeed. And so that's something that both employers and employees have to be very aware of in terms of dealing with that issue. Now, in terms of your question about false accusations, if there's a termination for cause following allegations of, I don't know what kind of allegations these would be, Carlotta, but if it's harassment, if it's bullying, whatever they are, the employer would have to launch an investigation. And a best practice would be for the employer to hire a third-party investigator, somebody whose job is investigating these things, rather than someone who actually works at the company, and have that investigator go through the allegations, speak to the people involved, get everybody's version of events, and then specifically, if you're the person who's being complained about, give you the opportunity to respond and provide a fulsome account of what happened from your perspective. And then there's a conclusion that will be drawn based on all of the evidence provided from everybody. And so if the employer hasn't done that, you probably are in a situation where you could use that against your employer in terms of pursuing severance. It will really depend on what the allegations are. And it will depend on what the employer did or didn't do prior to your termination. But what I can say is, if truly the allegations are false and you didn't do anything wrong, then certainly there is a way to pursue your severance. Because again, unless you've engaged in very serious, willful misconduct, the odds are that your employer will not be able to make out a case for a cause termination, and you will be owed your termination entitlements and your severance. So in your situation, Carlotta, I would actually recommend that you get in touch with us. Again, you can email us at help@employmentlawyer.ca, and you can go to our website, employmentlawyer.ca, and you can speak with a lawyer or myself, any lawyer at our firm, who can go over the whole situation with you and figure out, what exactly happened and how you can go about pursuing your severance. Because, of course, if you are let go due to false allegations and they're alleging that you did something wrong and you didn't do it, certainly there is a way to deal with that, and we assist people with that all the time. So definitely get back in touch with us, and we're happy to help you however we can. Okay, we're running low on time here. I'm going to answer one more question from Steven on YouTube, who asks, can you claim a constructive dismissal if your employer has promised to move you to a new role repeatedly, given you new responsibilities for that position, but then does not give you the new role? So, in terms of a constructive dismissal, there would have to be changes to your employment, significant changes to the terms of your employment that are being forced on you. So, for example, if let's say an employer was going to make you do a new role, which was going to be more responsibility, more work, maybe even more hours, but was not going to make the pay commensurate with that and was not going to offer you the pay that would be required for you to do that, that could be a constructive dismissal depending on the circumstances. An employer telling you that they are going to move you to a new role and then not doing it, that would not be a constructive dismissal, because that is not an employer making changes to the terms of your employment without your consent. That's unfortunately a situation where an employer is telling you something and then not doing what they say, which is very frustrating and very upsetting, but it's not something that would amount to a constructive dismissal. In your example, Stephen, you've said that essentially it sounds like they're making you do the new position without actually giving you the title. If that's the case, I go back to my first example, where if an employer is adding additional duties, and it's a significant amount of additional duties, such that you're basically doing 2 jobs instead of 1, but they're not giving you the pay that should go along with it, that could be a constructive dismissal. And that's where I go back to what I said earlier, which is, if that's something that's being forced upon you and you continue working under those conditions, you'll be deemed to have accepted it. So it's really, really important that if you're in this situation, that you get in touch with us right away so that we can review this and advise you accordingly on how to push back. Because again, if you do this for, a certain period and you're doing the new responsibilities, carrying out the new responsibilities without the title or the pay, at a certain point, you're going to be deemed to accept that. And then you won't be able to pursue the title and the pay or a constructive dismissal claim. So if this is the case, like I said before, get in touch with us and we can review the situation and advise you accordingly. But it sounds like time is of the essence here. It sounds like this is already happening. So don't waste any more time here, Stephen. Get in touch with us right away so that we can help you. So I know I have a few more questions I didn't get to. Unfortunately, we're out of time for today. So any questions that I didn't get to, please feel free to contact us, help@employmentlawyer.ca, or you can tune in on Monday for our next question and answer session live with one of my colleagues and ask your question then. Thank you very much, everyone, for tuning in and for your great questions, and have a wonderful weekend.